We're on the record in the matter of the people of the state of Michigan versus John Anthony, file number 23-0035-340 FY, council appearance.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Anthony for purposes of arraignment only.
Go all the way up.
So where?
Yeah, perfect.
He is already a client of our office.
Thank you. You're John Anthony?
Yes, Your Honor.
Okay, Mr. Anthony, you were previously arraigned on this matter about a month ago, actually on February 13th. You had a probable cause conference and your matter was supposed to continue to an examination. Your examination was scheduled for March 2nd. You failed to appear.
This is where the trouble begins. A probable cause conference and examination. A preliminary hearings in a felony case in Michigan. The examination, also known as a preliminary exam, is where the prosecutor presents evidence to show the probable cause to believe a felony was committed and that the defendant committed it. Failure to appear for a scheduled court date, especially on a felony, is a serious offense in itself. It can result in a bench warrant being issued for the defendant's arrest, which is precisely what happened to Mr. Anthony. Michigan Court Rule 6.004 outlines the process for warrants and summons, including a failure to appear.
Yeah, I'd like to throw myself at the mercy of the court, Your Honor. I picked up a job house sitting and watching a friend's dog, and the dog had become ill, and it just so happened to be on the court date, and it completely blanked my mind when they called me to come over there to take care of the dog and help out with that. I didn't realize that I was going to miss my court date, but I have the court date memorized today. It is 4/13, Your Honor, at 8:30 a.m. And I completely apologize. You can see the last both times that I've been arrested, I haven't incurred any new charges, ran away or anything like that. I am very, very happy and swear to God, I will come to court the next time. If you could please reinstate my PR bond, I will do that for you, Your Honor. I'm so sorry about missing the court date. It was not my intention whatsoever. But I have it logged into my head right now, burned in that it is April 13th at 8:30 a.m.
I recognize you have it logged in your head at this point. The concern is that if something such as dog sitting for someone can throw you off of remembering that you're supposed to be in court on a felony, that you're facing the maximum penalty of 5 years and or $2,000 in fines with a habitual offender third offense notice enhancing the penalty to twice the maximum sentence. I'm not sure that you reciting the date. I'm not sure that you reciting the date makes me feel like you're gonna come.
Here, the judge highlights the gravity of Mr. Anthony's situation. He's not just facing a felony, but his potential sentence could be enhanced due to being a habitual offender, third offense. Under Michigan complied law, Section 769.10, a third felony conviction can double the maximum prison sentence for the current offense. The judge's skepticism about him merely reciting the date is crucial. She's assessing his credibility and the likelihood of future compliance. This isn't just about the date, it's about demonstrating genuine reliability, especially when facing such significant consequences.
All
What
right,
if
Your
someone
Honor,
asked you to dog sit again?
the dog, I'm sorry, those are just my favorite animals and they mean a great deal to me. And I'm sorry, I apologize about that. I know it's not an excuse about missing court. This is a serious matter to me. It is very serious. I take this as serious and definitely more serious than the dog. It's just I'd like a chance to continue doing well and show you that I can do well by holding down this job and showing up to court. I apologize, and I will take this as the most serious matter as I can, because losing my freedom means I can't do well and help anybody. I won't recite the court date again, Your Honor, but it is burned into my memory, and I will come down here, and this is important to me. It is important to me to.
You can address bond.
Your Honor, I would just basically stand on what Mr. Anthony has told you. It's a similar story to what he told me this morning. He is a longtime resident of the Lansing community, and since he is out working and being a productive member, I would be asking for one last chance at a personal recognizance bond. Thank you.
Have you been reporting for your analysis testing?
Ma'am, I'm not sure.
The public defender makes a conscious argument, essentially reiterating Mr. Anthony's stated intentions. However, the judge immediately cuts to a critical point: random urinalysis testing. This is a standard condition of bond for many defendants, especially if there are underlying substance abuse issues. Mr. Anthony's hesitation, "I'm not sure" response is a major red flag. It indicates a lack of awareness or compliance with a basic condition of his previous release, which further erodes his credibility and suggests he's not taking his obligations seriously. This is a core reason the judge might deny a PR bond. If a defendant cannot follow existing rules, they are a greater flight risk and potential danger.
What? Yeah, I've been going to go get my Suboxone or whatever. I go up there and take drops for that. Yeah, I take UAs.
No. Did you turn yourself in on this bench warrant? How did you get picked up?
I was walking down the street and saw a police officer and stopped and talked to him.
This exchange is telling. The judge is trying to ascertain Mr. Anthony's sense of personal responsibility. Turning oneself in demonstrates an acknowledgement of one's legal obligations. Mr. Anthony's explanation that he saw a police officer and stopped and talked to him is bizarre. It doesn't sound like a proactive surrender, but rather a passive encounter. This lack of initiative and his subsequent responses highlight a significant discontent between his stated remorse and his actions, further damaging his case for personal recognition bond. Michigan law expects individuals to comply with warrants.
Oh, okay. You stopped and talked to him and he told you you had a warrant?
No, I pretty much told him I missed a court date. I think I might have a warrant.
Why didn't you turn yourself into court when you knew you missed court?
I'm not quite sure how to do that. I thought that was just the easiest way for me, Your Honor. I'm not quite sure how to go. I don't know what day to show up to not be a burden to the court system. Is what I mean.
You don't know which way to show up to not be a burden to the court system, you said?
Because I know you guys are busy and you have a court docket. I don't know which day to come in, like that is warrant day or whatever. And I thought that this was the easiest way to come in and get in front of you, was to come into this. This is just the only one I've known how to do it.
Who's this public defender?
Mr. Hess, Your Honor.
Okay. When's the last time you spoke to your attorney?
That was at that court date. That was the last time. He hasn't called me at all, and I haven't called him. I figured I'd go and come and talk to you first and get another court date before I talk to my attorney again.
Okay. What's your phone number?
It's 243-8694. 517-243-8694.
That's not the number that you provided at your arraignment. So maybe your attorney doesn't have a valid number for you.
The judge's discovery of a changed phone number is critical. Providing accurate contact information is fundamentally requirement of bond and probation. If his attorney can't reach him and the court can't reach him, it directly impacts his ability to fulfill the court orders, appear at future hearings, and maintain contact with his legal counsel. This concrete piece of evidence further confirms the judge's growing doubt about Mr. Anthony's reliability and commitment to his legal obligations. It strengthens the argument against reinstating the PR bond, as he cannot even maintain his basic communication.
What is the 214 is the other one?
You tell me what number you provided. Did you have another number?
No, that is the only other one that I can remember at this time, Your Honor, is the 214. And that the eight,
I'm not confident that he's gonna return to court on his own recognizance.
I
Personal
will.
recognizance is denied at this time. Bond will be set in the amount 2,010%.
And there it is. The judge explicitly states her lack of confidence, which is the cornerstone for denying personal recognizance bond under principles outlined in Michigan compiled law, section 765.6. Instead, she sets a 2,010% bond. This means Mr. Anthony would need to pay 10% of the $2,000 bond, which is $200, to be released. This money is held by the court and typically returned, less administrative fees, if he appears for all future court dates. If he fails to appear, the entire $2,000 becomes due and he forfeits the $200. This type of bond provides a financial incentive for the defendants to show up. Unlike a PR bond, the judge has decided that Mr. Anthony needs a tangible financial stake to ensure his return.
Your next court date before Judge Ward is going to be April 13, 2023 at 8:30 in the morning. Do you have any questions at this time?
No, thank you.
Okay, you're all set.
Yep.